Next up we have Alan Koenck. He's a shareholder at Kinney & Lang and will be presenting today for us on another Supreme Court case, Nautilus v. Biosig Instruments. Has to do with the new standard for definiteness in patents. So with that, I welcome Alan.
Thank you, thank you. Well, that was, I was listening to Jason's talk, and that was some really great information and pretty heady stuff, I thought. I learned a lot of concepts and pretty complicated ideas that I think are really interesting, and made me kind of think that my presentation can kind of be a chance for you all to take about a 20-minute deep breath now and maybe decompress a little bit, because this is going to be a lot easier to learn about. If this were a wedding dance, this would be the slow dance portion right after the big fast song where all the kids are out there. And now's the time where all the guys who can't dance can get up and not worry about making an idiot out of themselves. So that's where we're at in our presentation. I'm going to talk about definiteness of patent claims, and really the basis for choosing this topic was the Nautilus versus Biosig Instruments case that was decided a couple weeks ago in the Supreme Court. And this is one of those cases that was identified because, the Supreme Court doesn't really take that many patent cases, and so when they do, it tends to be a pretty big deal. And as it kind of turned out from this case, doesn't seem like maybe it's quite as big a deal as it seemed like it was going to be, and we'll kind of go through why that's the case. So I'm going to use this as an opportunity to meander around some patent law principles that I'd like to talk about that I think are interesting, using this case as a backdrop for that, and also, of course, teach you what the holding of the case was and what implications that'll have as well. So for those of you who aren't patent attorneys, and I know there's many of you out there who are not, just talking for a minute about what patent claims are might be instructive. The claim of a patent in the United States is the part of a patent. It comes at the end of the patent, and the function that it serves is to define the outer boundary of the exclusive right to practice the invention that is defined by those claims. So you're using a combination of words, usually a combination of what are called either elements or limitations, that you describe in words, in text, that gives kind of enough definition to what you have that tells the public what you've done that no one has ever done before, and therefore what you're entitled to that exclusive right for, the exclusive patent right. And so there's two parts to that exercise of creating a patent claim. The first is to make sure that you are not including in your definition things that have been done before, which is called the prior art. So in order to get a patent, you have to exclude the prior art. You can't cover what's been done before. But then on the other side of that coin, the other thing you're trying to do with a patent claim is to include everything else that hasn't been done before that fits within the description of your invention that you have. And so there's this kind of drawing the line exercise, and you're trying to draw it in exactly the right place with your words. And that can be a non-trivial challenge for patent attorneys working with inventors to define. And so that's why you see so much argument in these cases about that concept. So the requirement for patent claims to be definite is a statutory requirement in 35 U.S.C. 112. The second paragraph is how I'm used to referring to it. The law change a couple of years ago actually changed the numbering of that, so now it's 112B. And it says that the specification, this is of a patent application, shall conclude with one or more claims that particularly point out and distinctly claim the subject matter, which is the invention. So particularity and distinctness is in the statute. Federal Circuit case law, and the Federal Circuit is, of course, the court that hears all the appeals related to patents, has created a standard in dealing with that distinctness and particularity requirement that says that a claim, when they see it, a claim is indefinite only if it's not amenable to construction or is insolubly ambiguous. And what those words essentially mean for the court there is that they cannot assign a clear meaning to the claim at all. Not that there is only one clear meaning that is apparent to everyone, but that after they work through it with the text that's in the claim, they can't get to a construction of the claim. They can't tell what it means. So again, as I kind of mentioned, the whole point that underlies this is that those out in the world, when they look at a patent, they need to be able to know from reading the claim whether they infringe that patent or not. That's really, you're going to hear that concept a couple of times more as we go through the case. But that's what's important about a patent claim being definite, is that when you look at a patent, you're not kind of taking a 50-50 risk whether you infringe it or whether you don't, based on the language that's there. You need to be able to figure out what it is. So that's the exercise that we're going for. And the Federal Circuit standard, at least as it's written here, has appeared to many to be too permissive of ambiguity, right? It says, well, it's only indefinite if we can't, after lots of work, assign any meaning to it. And so you can see where that's not quite the same concept as this idea that you have to be able to tell, looking at a patent, whether you infringe it or not. So that's kind of the backdrop for where we're headed here. Now my next slide, just in case any of you are sensitive to disturbing images, you can look away for a minute if you want to. I find this next one quite disturbing. This is a machine that is used to torture people hopefully you can see what that is. You actually have to climb stairs without getting anywhere in this machine. I can't believe that they allow these out in public. And they also, you can't see it, but this person holding the handrails has electrodes underneath them, which it turns out is actually just for monitoring your heart rate. But it sounds to me like something that should not be allowed in the public. In this case, I should have been about that, but apparently it was more about whether those electrodes are configured in a way that allows the heart rate signals to be more clearly identified. And so that's what this case is technically about, is about the spacing of the electrodes on those handrails of a Stairmaster. And the spacing was actually important in the patent that Biosig had, because it allowed them to cancel, if they spaced the electrodes in a certain way, it allowed them to cancel out signals that would interfere with the heart rate signal, and so they could get a more clear view of what that heart rate signal is. So that's really what this slide is about. The signals that you want are called ECG signals. The signals that you don't want are called EMG signals. And if you space electrodes on these handrails appropriately, and Biosig was the ones who figured this out, you can get equal bad signals on each hand and then subtract them from each other to cancel them out to zero. So that's really what was going on here. So that's what they were trying to claim as their invention, in a way that was as definite as possible while reading on as many things as hadn't been done before as possible. So they're walking that line with their claims, and we'll see how they did that. So claim 1 of the patent that Biosig had talked about a heart rate monitor on a cylindrical bar, with each half of the bar, that being your handrails that we were talking about, having a live electrode and a common electrode. So there's your 2 electrodes that are spaced from each other. And the claim said that they are mounted in a spaced relationship with each other. And then further down in that same claim, there was language in the claim that talked about the fact that the spacing resulted in these signals on each side being equal so that they could be canceled out. And the phrase "in a spaced relationship," as you might just look at this and kind of intuitively figure out, that was the language that it was unclear to the infringer, at least that was they alleged. It was unclear what kind of spacing was required to infringe that claim. So that's kind of the backdrop for this entire fight. So first, before the litigation actually got going in earnest, there was a re-examination of Biosig's patent in the US Patent Office. And evidence was submitted in a declaration by the patent owner there, saying that a person skilled in this art was able to, based on the teachings of this patent, determine what spacing was needed to get those equal signals from each side. So again, the whole fight here is if that claim had said that the electrodes were spaced by an amount between 5 and 10 millimeters, for example, we wouldn't be in this situation, right? But the reason that they didn't claim it that way is because the spacing really depended on the configuration of the machine that this was going into. And their invention was applicable to any machine that it went into, but you had to do a little bit of tuning and technique work there to make that signal come out the way you needed it to. And so it's one of those inventions that is, you can imagine that's a little bit difficult to claim in a really clear way because you can't just use numbers to define it. It's really a concept that's bigger than that. So they said in their arguments that the spacing, shape, and size were not standard, but could be determined by a trial and error process, and that process itself had a result that could be measured, and that was kind of the way they proceeded. Patent Office agreed with that, and the patent was issued after the reexamination was done. So the lawsuit then commenced after reexamination in the Southern District of New York. There was a hearing to determine what the patent claims meant. Nautilus, the defendant here, in the claim construction context, so the thing to remember about the position of Nautilus here is that they're defending against a patent infringement charge, right? So they're kind of like if you picture someone who's falling in quicksand, they're just reaching for anything they can to defend themselves here. So they're going to go for everything they can reach. They're going to say that the claims should be construed in a narrow way so that they don't infringe the patent. And if that fails, they're going to say, well, now the claims as they read are disclosed by the prior art and shouldn't be valid, or they're indefinite and shouldn't be valid, and that's exactly what happened here. So their first argument is, hey, the spaced relationship should require that they be spaced greater than the width of the electrodes. So the examples in the case showed that that was the spacing that in one of the examples, and they said that should be what the claim should be limited to. The district court did not do that construction. They didn't narrow the claims beyond the meaning of the terms on their face, and that's a pretty typical thing. For those of you who've been involved in claim construction, the term that's usually used is the plain meaning, or the plain and ordinary meaning of the terms will govern, unless there's some reason to depart from that. And in this case, that they weren't able to show that those examples were actually limiting examples that would cause that to be the case. So just kind of a good thing to remember about claim construction is that plain and ordinary meaning is usually going to rule the day when you're trying to figure out what these things mean, unless you have something really specific to point to that puts you in a different place than that. So once that claim construction was done, Nautilus is now in a position where they have an infringement problem, right? Because that claim is broad, it covers any defined spacing, and they have spaced electrodes. So the next thing to do was to say, I don't know what spaced relationship means. That's too broad or too indefinite to be a valid claim. And in this instance, the district court agreed with that and said, when I look at that term, I don't know what that means. I don't know what spacing is covered and what spacing is not covered, and therefore that claim is indefinite. So again, what they're looking at is the public notice was not provided by that term is what the decision was based on. So the Federal Circuit took this up, and remember what standard they're applying. We talked about it just a little bit ago. They're looking to see whether there is any construction that can be given to this claim or whether it is insolubly ambiguous, whatever that exactly means. And so they were able to look at the teachings of this entire patent and say, well, you know what, we know what this means. This means that the spacing is enough so that they're not electrically connected to each other, right? Because you have to have a signal passing through the person's hand, the electrode, person's hand, and then to the other electrode, right? So two distinct points of the hand have to be touched. They have to be spaced by that amount. And most importantly, the spacing has to be adjusted in a way that those EMG signals on both hands are equal. And I think that here really was the key, is that there was teaching about that. There was even another claim limitation that dealt with that. And so it seemed like to the Federal Circuit that you could figure out what this meant, and you could figure out when you infringe because you would know that those signals cancel out, and that's a definite thing. So the Supreme Court picks up this case, and the main issue for them to answer was whether that standard for indefiniteness is actually correct. And just to kind of give you a little bit of background and defense to the Federal Circuit, those terms of insolubly ambiguous and amenable to claim construction, that wasn't the only analysis that they were doing. They were looking at a lot of factors to determine indefiniteness. In particular, they're looking at whether the specification of the case, the detailed technical description, gives you some kind of an objective standard for figuring out what the terms in the claim actually mean. So the datamized case, which is the one that kind of is usually pointed to as setting the standard out, was actually a case where the claims were found to be indefinite because the claim term was that something was aesthetically pleasing. And the Federal Circuit said, no one can figure out what that means. That's subjective, right? There's no objective standard for that. So for patent practitioners out there, words like aesthetically pleasing, and in hindsight, it's always very clear, right? But that's a term, the sort of term that, on the one hand, you can't probably rely on it to distinguish from what's been done before. Not really, because it's not a term you can say, well, this has it and that doesn't. And so if you've got something that doesn't distinguish from what's been done before, why have it at all, right? You don't need that sort of language in your claim, just leave it out. But that was what the datamized case was about. So the new holding by the Supreme Court, here's kind of the money slide, right? This is our holding from the case, where we get this new standard of indefiniteness that we can really work with going forward, is that the claim needs to inform with reasonable certainty those skilled in the art about the scope of the invention. And that is not exactly a black and white rule that you can use and look at a claim and say, oh, I know now whether this is definite or not definite. And that kind of is the problem with this and how you would use it going forward. What we do know is that the Supreme Court said that the Federal Circuit Court allowed too much ambiguity to be considered definite. So we know which direction the line moved, right? It moved towards requiring more definiteness in your language for a claim to survive this kind of a challenge. So even further than that, the Supreme Court said that they're not a court of first view, but only a court of review. And so they did not decide on the facts in front of them. They remanded the case to the Federal Circuit to apply this new standard and decide the case. So we didn't even really get what we would have liked to see, which is how you're going to apply that standard to the facts that are in front of you. The prevailing wisdom on this, and the Supreme Court kind of alluded to it as well, is that these claims will still be found to be definite under the new standard because a lot of the issues that they said should have been considered, the parties weren't really arguing that much about. It seemed, and the Federal Circuit justices and the Supreme Court justices all were kind of saying very consistent things with each other. And so it looks like this is going to be one of those cases where the outcome may not change, but the standard for future cases is now something more towards the middle than where it was before. Exactly where is difficult to ascertain. So that's where we're headed going forward. Just a few thoughts about what this decision means, the analysis that we can do. The presumption of validity of patents, that's a concept that's used when patents are reviewed for validity in a court, is that there's this bar that's higher than a preponderance of the evidence that you have to show in order to knock out a patent. There's this presumption that the Patent Office did a good job in allowing the patent. It's not something you can't overcome, but the bar is higher. Now, because the because the standard for determining indefiniteness that the Supreme Court laid out is actually very similar to what the Patent Office set out, it's possible that you might see the Patent Office's decision on definiteness getting some deference there. But yet again, you have them saying in a lot of language that the ambiguity that was tolerated before will not be tolerated going forward. So what may actually happen is that this may drive the Patent Office to be a little stricter in their determinations of whether something is definite as well, because that message is going to get sent down from the Supreme Court decision. The other one in this set I wanted to talk a little bit about was this problem that was mentioned in the oral arguments quite a bit for this case, and that was this two plausible constructions problem. Which is that you've got a claim, and here's the language, and there's two ways to read it that both seem to be plausible. And so the question that was asked in the oral arguments quite a bit was, is that by definition an indefinite claim? Because there's two plausible meanings to it. It seems like that's on its face confusing to people knowing whether they infringe. And so there was a lot, as I mentioned, a lot of talk about that issue. And it was not addressed in the decision at all. And so that seems to be something to look for going forward if you have, and in most really tightly contested patent cases, you have both sides coming up with a different construction of the claims. They're putting a lot of effort into it. They're putting time and resources into this construction issue that both sides obviously have very vested interests in getting the construction that they want. So there's going to be a lot of cases where there is a set of two plausible constructions on both sides. And the question is going to be, well, how much more plausible does one have to be than the other for the claim to be considered clear and definite, versus if they're both equally likely, is that going to be clearly indefinite? So that's kind of one way to think about whether you have a situation where claims are not going to survive this kind of a challenge or not, if there's these constructions that are so similar in likelihood that they seem to really conflict. I've got a few examples of Federal Circuit decisions on claims that I pulled these thinking, well, let's look at these and decide whether we think the outcome would be different under the new standard from the old one. And I kind of had, I put these up here because I kind of had a hard time figuring out how the outcome would be much different. At least in these cases. So here's the first claim example is a claim that says that there are linkage groups not interfering substantially with hybridization. And of course, the problem with that claim is this idea of substantially interfering, right? You don't know what the boundaries of that are. But in that case, the description in the patent application gave a lot of insight into what that meant, what the boundaries of substantially interfering should be. And so the Federal Circuit found that to be definite because of all those teachings, and said, hey, a person of skill in the art would look at that claim, look at the whole patent, in fact, and be able to figure out what that meant. I would tend to think that that would still be the case under the new standard, because the idea would be that the patent teachings give you reasonable certainty into what the terms mean. The next one had to do with fine granules having an average particle diameter of 400 micrometers or less. Now on its face, that looks really definite, right? We've got numbers defining that. The problem in that case was there were more than one way to measure average diameter, and if you use the different methods, they might give you a different result. And so the defendant in that case, again, reaching for anything, right, as you're sinking, is saying there's more than one way to look at this. Depending on which one you choose, one way might put me in the infringing side of things, and the other might keep me out of it. And so the court in that case, again, found that claim to be definite and said that, despite the fact that there's different ways to measure this, you really would have to show a very specific reliance on a measurement you made that came out with the wrong answer to put you in a place you didn't expect to be, to show that that was too unclear. And again, I think that's probably how the analysis would be done under the new standard as well. You look to reasonableness, right, of what you're doing. And then the last one is a little bit more complicated. It's a software case where the limitation is defined as a means plus function. And so real quickly, that's just a way to describe what's new about your invention as being the function it performs without limiting yourself to a particular structure, as long as you teach the structure somewhere in your description. And so in this case, the claim was found to be indefinite because the description didn't teach the algorithm that performed the function that was set out in the claim. Another case where I'd be hard-pressed to find that it'd be any different under the new standard, particularly because this one was found indefinite. I think one thing we do know is that the line has moved in the other direction than that. You're not going to be finding previously indefinite claims now definite. It's going to be the other way around, right? So again, a case that probably isn't changing the way it's looked at under the new rules. So I know there are fact patterns out there probably that are going to be affected by the new standard, but it's kind of hard in the abstract to think what they will be. I think maybe when we see a case that comes out, you might have some context to make that decision. So last point that I want to make is looking at how the Federal Circuit / Supreme Court, basically any court, looks at definiteness, and how the US Patent Office looks at definiteness. They have been allowed to use different standards for how they do that, and there's a Federal Circuit case actually earlier this year that explicitly said that. That was back when they were using this insolubly ambiguous standard, and the decision said, Patent Office, you're free to use your stricter standard than that to evaluate definiteness. You don't have to use the Federal Circuit standard for that. So the USPTO looks at, and then the standard is here, whether the claim sets out a particular subject matter with reasonable clarity and particularity. Sounds very similar to what the Supreme Court just said the standard should be. So it seems like things are coming more in line going forward than they were even before the new case. So the last thing I'll leave you with is, if you happen to do a Google image search for indefiniteness, one of the first things that comes up is this method here, a method of eating chocolate indefinitely. So I'll let you kind of ponder that as I leave to find the geometric trick that allows you to cut the chocolate in various pieces and have an extra square left over indefinitely to continue to eat your chocolate. If anybody can make it work, please find me afterwards. I know lots of people who would be interested. Well, thanks very much. I appreciate your time and everybody being here, and I hope you're having a good afternoon. Thanks.
Thanks, Alan. Again, we're going to keep moving along. We have one more presenter, and then we'll take a break. Our next presenter is Matt DeRuiter. Matt is an associate at Kinney & Lang, and he'll be talking about what is meant by exceptional cases.